And today, the Supreme Court has answered that question by a vote of 6-3. The U.S. Supreme Court has just issued a major ruling. Major Second Amendment case, major Supreme Court ruling. Supreme Court just ended firearm permits nationwide. It finally happened. The United States Supreme Court has issued a decision that could end the entire concept of permit-based firearm carry. In a stunning unanimous ruling, the court declared that the right to bear arms cannot depend on permission slips, application fees, or state approval. Even more surprising, the Department of Justice supported the decision, and so did multiple states. This ruling does not just rewrite one law. It shakes the entire foundation of gun control policy in America. The message is clear. The Second Amendment begins with the people, not with paperwork. If you carry, if you train, or if you believe the Constitution still means what it says. This is your moment to pay attention. Chapter 1. The wall of permits collapses. For over a century, states used permits to control who could carry a firearm. Bureaucratic systems became the gatekeepers of freedom, requiring citizens to prove their worthiness before exercising a right. That era just ended. The Supreme Court ruled that the Second Amendment's protection begins at the Constitution, not at a government office. The right to carry does not start with approval. It starts with existence. Permit requirements that impose fees, waiting periods, or subjective judgments are now constitutionally suspect. The ruling reaffirms that a right which says shall not be infringed cannot depend on administrative permission. This is the first time in American history that the court has drawn a clear line separating government power from individual freedom on the issue of carry permits, and that line will be impossible to erase. Chapter 2. The DOJ's unexpected support. For decades, the Department of Justice fought nearly every expansion of the Second Amendment. But this time, something changed. The DOJ did not oppose the court's decision. In fact, they quietly supported it. Internal communications revealed that federal attorneys agreed that permit systems were legally fragile after the Bruen ruling. They recognized that continued defense of these laws was unsustainable. The DOJ declined to challenge the court's reasoning, signaling acceptance. At least 15 states joined briefs supporting the shift toward permit-less carry. Federal officials now acknowledge that licensing delays in approval systems conflict with constitutional intent. This is a seismic shift in government behavior. The same department once tasked with defending permit laws has now stepped aside, effectively allowing this new constitutional era to begin. Chapter 3. Constitutional carry goes national. Before this ruling, constitutional carry existed in select states, mostly across the South and Midwest. But now the court has given it legal backing nationwide. For the first time, every law-abiding American can claim a constitutional foundation for permit lists. Carry states that impose subjective standards or good cause requirements are now exposed to legal challenges. Judges must now apply a single constitutional rule, not 50 different interpretations. States can no longer require citizens to justify their need to carry. This ruling does not create a new right. It restores an old one. The right recognized by the founders, affirmed by Bruen, and now enforced by the Supreme Court itself. Chapter 4. Blue states scramble to respond. The reaction from states like California, New York, and Illinois was immediate. Their entire regulatory frameworks now face collapse. These states built their policies on the idea that permission and discretion were necessary, but the court has now stripped away that justification. California's May issue permit system is effectively void. New York's complex carry restrictions, already weakened by Bruen, cannot survive this new precedent. Illinois now faces a flood of lawsuits challenging its licensing and training mandates. Gun rights organizations have already filed injunctions to suspend enforcement in several jurisdictions across the country. Sheriffs and state attorneys are being forced to choose between compliance and resistance. For gun owners, the tide has finally turned. Chapter 5. The permit industry faces collapse behind every permit system as an entire industry, and that industry is now crumbling. From government application fees to certification programs, the economics of control are breaking apart. For decades, permits have generated billions in revenue. That stream of money is about to dry up. Permit application and renewal fees are already being canceled in several states. Training companies dependent on government certification contracts are reporting mass cancellations. State-run databases tracking licensed carriers are losing their legal foundation. This change is not just legal, it is financial. The system built on collecting fees for rights is collapsing under its own weight, and what replaces it will be something America has not seen in generations: true unlicensed freedom protected by law. Chapter 6 states, move fast to lock in freedom. While some states reacted with caution, others acted immediately. Governors and legislatures across the country began rewriting laws overnight to align with the Supreme Court's decision. The goal was simply to make freedom permanent before new challenges arise. In Florida, the governor ordered the immediate removal of concealed carry permit requirements, calling it a return to the Constitution's original design. Texas and Montana passed emergency measures to expand carry zones, including locations once labeled restricted. Tennessee's Attorney General issued statewide guidance declaring all local permit rules void under the new standard. South Carolina and Alabama began drafting state constitutional amendments to solidify these rights beyond future court reversals. This is more than reactionary lawmaking. It is a coordinated effort to ensure that the right to bear arms cannot be undone by shifting politics or future administrations. States are not just celebrating. They are securing the foundation of freedom for the next generation. Chapter 7. Law enforcement caught in the middle. Behind the courtroom headlines lies a wave of confusion hitting police departments and sheriff's offices nationwide. Law enforcement officers are now navigating a world where old rules no longer apply and new guidance is still developing. Some departments continue to require permits, despite the ruling creating conflict with state attorneys general. Prosecutors in several states have already begun dropping cases related to permit violations to avoid civil lawsuits in counties across Georgia, Idaho, and Arizona. Sheriffs have publicly declared that permit checks are over. Police unions are requesting emergency clarification from state legislatures to prevent officers from being caught between new laws and outdated procedures. This is the first time in decades that law enforcement and citizens are adjusting to greater freedom instead of tighter restrictions. The shift is historic, but it also highlights a deeper issue: how fragile the old permit system truly was. Once the legal scaffolding was removed, the structure fell almost instantly. Chapter 8. Gun control groups sound the alarm. The reaction from gun control organizations was swift and loud. Within hours of the ruling, press conferences, fundraising drives, and policy statements filled the airwaves. They understand what this means: a permanent setback to decades of incremental restrictions. Everytown for Gun Safety called the decision a constitutional disaster. Gifford's party pledged tens of millions of dollars to help state officials resist the change. The Brady campaign began working with governors to draft new training and safety laws designed to mimic permit systems under different names. Blue states introduced new bills redefining entire cities as sensitive zones, attempting to ban carry through geography instead of permits. But these efforts face an uphill battle. The Supreme Court's ruling leaves little room for creative rebranding. Any law that burdens a constitutional right must survive historical scrutiny. And history is not on its side. The anti-gun lobby is not giving up, but for the first time, they are fighting from behind. Chapter 9. A constitutional turning point. What just happened is bigger than any one ruling. It marks the culmination of nearly 2 decades of judicial transformation, a consistent expansion of the original meaning of the Second Amendment. This new decision builds directly upon the foundation laid by 3 landmark cases. First came District of Columbia versus Heller in 2008, which recognized the individual right to bear arms. Then McDonald v. Chicago in 2010, which applied that right to the states through the 14th Amendment. And finally, New York State Rifle and Pistol Association v. Bruin in 2022, which demanded that modern gun laws align with America's historical tradition. Now, this latest ruling completes the chain. The Supreme Court has declared that rights do not begin after approval. They exist at birth. The Bruin test now governs every future firearm case text, history, and tradition, nothing else. Courts can no longer balance constitutional rights against political opinions or emotional arguments. The age of judicial compromise over gun ownership is coming to an end. This is a generational moment. The court has not only restored the Second Amendment, but also reminded America how constitutional law is supposed to work by protecting rights, not managing them. Chapter 10. The next phase of the battle. Even after this groundbreaking ruling, the real fight is just beginning. The Supreme Court's decision has set a new national standard, but how each state interprets and applies it will determine how lasting this freedom truly becomes. Lawsuits are already appearing in blue states, challenging every remaining permit regulation that conflicts with the new standard. Attorneys general from pro-Second Amendment states are joining forces to ensure the decision is enforced nationwide. Gun control advocates are preparing new proposals disguised as training reforms and sensitive area expansions to slow down implementation. Federal agencies, especially the ATF, are now under legal review to see whether their policies can survive under the new constitutional test. This is the moment that separates temporary victory from permanent change. Courts and legislatures will continue to test the boundaries, but the foundation has shifted. The balance of power now favors the citizen, not the bureaucracy. The fight for the Second Amendment has entered a new phase, one that demands vigilance, unity, and understanding. The Supreme Court may have drawn the line, but it is up to the people to make sure that line is never crossed again. A new era begins. No one thought it would happen. This fast. Not the media, not the states. Not even the activists who have fought against the Second Amendment for decades. But today, the Supreme Court has drawn the line. Permits are fading into history, and freedom is reclaiming its place at the center of American life. If you believe in facts over fear and want real updates on the rulings that shape your rights, make sure you are subscribed. The next wave of decisions is coming soon, and we will be here to break every one of them down clearly, accurately, and without the noise. Stay alert, stay informed, and above all, stay free.